this is the public-facing PACE monitor. And this shows all the correspondence from when the case began, when it was filed, the original complaint, and all the way to present day up here. And on PACE Monitor, we have the letter response to ECF number 15, pre-motion conference letter by Alyssa Mercante. And it says, J. Remy Green, it's from. So when you click on this, it brings up, oh, you got to pay to get access to it. But guess what I have, guys? I have access to it. So we're going to go through this. And I don't think I've seen anyone talk about this yet, but this is public information. So anyone's welcome to pay for it to get it. I will provide it to you free of charge. Cohen and Green, Honorable Margot K. Brodie, and this is from Alyssa's counsel, J. Remy Green, to Judge Brodie. And this is 4 pages talking about what their response is to the meeting, saying, hey, here's the information. This is why we want to proceed with the lawsuit. My firm with co-counsel represents plaintiff. The above case, I write per the court's rules on May 12th, minute order, to respond to defendant's new pre-motion conference letter, following plaintiff's amendments as of right and by consent, as briefly discussed below. Defendant's arguments are without merit. I mean, that's great. You know what I read this as? This is fan fiction. These are words that is put together. This is trust me, bro. Those words of they lack jurisdiction that has been established in court cases since forever. Apparently the lacking jurisdiction is without merit, which is a wild claim to make in the court of law, but okay. I'm no lawyer, so I guess these lawyers can slay. This is now defendant's second attempt at a pre-motion letter. I mean, yeah, you've also had how many attempts at a motion letter? This is how it works, back and forth, along with a fully briefed motion served on the plaintiff. Yet, defendant has barely, if at all, responded to the operative complaint. Because we don't know what your complaint is. What is your complaint? It's 89 pages of words. What are you suing me for? Like, what the hell? A brief telephone conference may help crystallize a more efficient and focused on the actual claims and elements approach to the briefing, but otherwise, plaintiff is ready to brief on the motion. So what I understand they're saying here is a brief, they are requesting a phone call with Ron to kind of hash out what they're really mad at and what they're actually wanting to take me to task on and what they want to sue for. They're like, sounds like Ron doesn't understand what we're suing for. So, and we've tried multiple times. So maybe we should call him and talk to him and say, hey, here's what we're suing you for, Ron. Almost like they're talking like Ron's a retard and he doesn't understand. And I'm like, no. We fully understand what you're doing, but we don't see you suing for anything legitimate here. That's our point. I don't understand how a phone call could crystallize your complaints. You had 3 different chances to do that. None of them scare us. None of them have any kind of jurisdiction or previous claims that have actually won anywhere in courts anywhere that I'm aware of. But they counter first with the 1. Defendant's personal jurisdiction arguments are meritless. First, defendant's argument the court lacks jurisdiction fails. That's quite a audacious claim. It fails. It fails to say it lacks jurisdiction because it's established that you cannot say someone that lives in New York if they're on the internet when they live in California. That's been well established at the courts. How does that fail? Like, that is literally the biggest hurdle that you have to overcome. And the way you're overcoming it is saying, oh, it fails. It does not address the amendments. The amendments of, look at all these other people we doxed that are in New York. And that guy, that YouTuber that we're suing, among all the people worldwide that he interacts with, he also interacts with people in New York. And because of that, those people in New York give him jurisdiction here. Well, if that's the case, the whole point of jurisdiction doesn't mean anything because the internet is literally everywhere. Whether under CLPR for non-defamation cause of action or otherwise, a course of action targeted at and integrated with New York is sufficient for jurisdiction. I mean, they can claim whatever they want, as we've seen with the 89 pages before. But no, they can say whatever they want. New York is not some random place. Yes, it is actually. It is some random place. It literally has nothing to do with anything. It is the center of this controversy because the person that's suing me lives there. That's why it's the center of this controversy. That is literally the only reason why I could see them say that is, oh, the person who lives here is in New York. So that's why it's the center of the controversy. Again, does not prove jurisdiction because that means anyone who sues anyone for anything says, oh, the center of controversy is where I am because I'm suing you. And that's the center of the controversy because I'm suing you. Defendants' connections with and intentional projections into New York are detailed at length in the SAC, yet barely addressed in his letter. Some highlights are below. It's barely addressed in the letter because it's a waste of time. Ron's not going to spend his time even giving you the time of day on that stuff because it's already been established with courts not to even care about that stuff. Just because you guys are trying to make an issue of it doesn't mean it's legitimate. It just means you're trying to make an issue out of it. Most clearly, defendant has deliberately targeted and projected his presence at New York. No, I haven't. You can't prove that. There's nothing I've done to deliberately target and project my presence in New York. I've never even been to New York since I started YouTube. What the hell? Plaintiff's former employer, Kotaku, located, again, nothing to do with me. Maybe she needs to sue Kotaku if that's where she is and that's her problem. Defendant conducted his #EndKotaku campaign, obviously directed at that New York business for the accomplished purpose of, among other things, ending plaintiff's career there. Among other things, as in trying to help her get better. Those other things, those details that you definitely don't want to mention here because it would make this all fall apart. That stuff. And on the prima facie tort stochastic harassment claims, which isn't a thing, by the way, I want to be clear about this. This is not a rule of law. This is not a thing. They keep talking about it like it's a thing. What they are doing is trying to use this case to establish stochastic terrorism as a law. That is, again, it can happen, but that is a wild thing to try to do with frivolous claims that they're throwing at someone. To establish a new case law off of what they're doing here is impressive. Not to mention, even if they had something, establishing this would still be a huge hurdle. But not having anything, it's like, what? Defendant's statements that he recognizes the publication of private information necessarily and inevitably leads to such harassment. What? You guys are the ones that doxed me. What? What are we doing here? Plus, his celebratory behavior after such events occurred, which I don't know what that's referring to, but sure, I celebrate certain things, just like your client celebrated taking my website down. People celebrate shit. Well, you're gonna sue over that? You're gonna sue over celebrations now? Show he specifically targeted the harassment to reach plaintiff in New York. Of course, the daily stream of rape and death threats that followed, again, nothing to do with me. I have never done any of that stuff. This is like defamatory to me by trying to connect it to me when it's not. You can't do this shit. You can't make these claims because I know you cannot back them up. So when you say this, it is actually putting you in a position of not a place I'd want to be. Next, defendants' downstream agents are largely clustered in New York. No, they're not. That is a lie. That is a factual lie. You have largely clustered people that I have interacted with in New York to try to fit this argument. But you are literally picking people individually out of a basket of thousands of people to find the people from New York and say, oh, largely clustered in New York. Largely. First off, what are you doing? Doxing everyone? How do you know this information? You can't even back up half the claims you're making. It's crazy. And he even appeared on multiple New York hosted shows. Which ones? On which he engaged in much of the conduct alleged. You don't know that. Again, this was already disproven. This is a lie that was disproven already. And they're still moving forward with it, even though we said that's not true. So now, and we know Alyssa's taking notes. So now they are now moving forward, knowingly wrong information to push a lie to try to trick the judge. Shows on which he engaged in much of the conduct alleged. Likewise, defendant's website is a New York-based operation. It's actually technically Israeli. Wix is owned by an Israeli company, not New York. They might have an office in New York, but that's not where they're owned out of. That website where he made some statements triggering Wix's terms of service with a choice are in New York. Moreover, the website paywalls content about plaintiff. No, it doesn't. Prove it. What's paywalled on my website? What's paywalled on my website? Why can't you show screenshots of anything paywalled? Oh, that's right, because none of it's paywalled. Because what I do typically do is I will paywall something for like a couple hours max while I publish a story, while I'm recording the video to go along with it. And as a benefit to people that are supporting me, they have early access to it. But every single article on my website is free. None of them are paywall. That's a lie. Another lie, by the way. Meaning defendant receives income from statements and conduct at issue. Well, if that's the case, I mean, I guess I receive income when I talk about anything, when people donate anything. Just because you sue me does not entitle you to that income. If that's the case, nobody would ever talk about anything ever. This is insanity. The website is highly interactive as relevant under case law. What? That interactivity is a major part of torts. Plaintiff receives revenue from that website growing out of the harassment and defamation. I would argue the money that I've made on my website is less than I pay to keep my website running. And I don't even need to like guess at it. I can guarantee you I spend more money on my website than I make coming out of it. So I receive revenue to run the website and I'm still in the red. That I could argue I'm not even making money on it. So what claim is this that they're trying to say? They're trying to make it sound like I'm making hundreds of thousands of dollars off this. Like, nope. I'm actually operating in the red on my website, but I like having my website up because if YouTube, I don't know, takes a video down, I can still have what I feel is public information that you're allowed to have out there because it's publicly facing on other websites that these people are at. So, well, if it's on the internet, I'm not doxing anyone. I don't have their home addresses on it. I'm not suing anyone. I'm not doxing anyone in lawsuits. Anyways, this goes on. I don't even know. Defendant derives significant revenues. Wait, how do you know this? How do you know I derive significant revenue from my projections into New York? He's made over 150 hours worth of videos and content. Well, it's probably 153 after tonight. Plaintiff and encourages downstream content creators to post content about her. Prove it. Prove it. So that he can react to that content. These are accusations that are made up because you don't like me. Where are your receipts for any of this? This is insane. Creating harassment and even more discussion regarding plaintiff that he can flog for views and revenue. But I commentate on information that is interesting, regardless of if you're suing me or not. Just because you're suing me doesn't mean you're entitled to that income. 2, defendant does not challenge the well-pled non-defamation claims. Defendant seeks to file a motion to dismiss, essentially exclusively briefing defamation doctrine and ignoring the remainder of the plaintiff's causes of action, claiming that they all sound in defamation. However, the explicitly narrow rule defendant is citing here has no application. It is black letter doctrine that where the alleged harm suffered by the plaintiff is not precisely the same that caused by defamation, namely harm to the plaintiff's reputation, which, by the way, before we even go on to 2.2 here, I want to be clear, as far as I understand, before we even get to that, if they can't approve jurisdiction, nothing else matters. Like the jurisdiction one is where the real problem is with this, which is why they've gone out of their way doxing everyone and try to make it sound like I literally work out of New York, where I don't. Like that is factually incorrect. That is a lie. You have to manipulate information to make it seem like that. And they know that's what they're doing. It's disingenuous and they know that's what they're doing. But then they go on to try to make it seem like I'm not Ron's not well pleading the non-defamation claims, which again, they're trying to claim that stochastic terrorism is a thing again, which again, it's not, unless this judge is retarded and doesn't understand that this is referencing some town in Oregon that approved one stochastic terrorism thing, like off the wall that had nothing to do with anything. That wasn't even like a full-on court. If they're trying to use that to establish like a new court of law from a township or whatever, they're going to have a bad time. I don't live in New York. I live in Oregon, you dumbass lawyer, which is why they don't bring you up on this. They're trying to bring other people that I do not interact with ever. Like Rev says Desu is named in the lawsuit. I've talked to Rev publicly on X, maybe interacted once or twice with him ever. I might have commented on one of his videos once or twice. As far as I understand, I have no DM interactions with him. I don't know anything about the guy. And they named him in the lawsuit because he's in New York. And I'm like, what the hell are we doing here? Rev says Desu. What? Anyway, 3. Plaintiff shifted defamation arguments lack a connection to the elements of a defamation claim. Defendant then turns to defamation, shifting from earlier arguments saying he relied on statements made after the statement sued over to now argue the plaintiff's public statements discussing sex work and where she stated that she used to be a cam girl, a girl who chats often in states of undress with viewers, and her defamation claim as a matter of law. But defendant never explained what element of defamation these statements would bar. What elements of defamation you're suing us over? At first, he seems to argue actual malice. Defendant could have reasonably interpreted statements to mean the specific facts he would state as months later, but the complaint does not allege defendant ever saw or relied on the statement mid-2023 in making statements in March 2024. In fact, specifically describes how defendant necessarily falsely specifically claimed he relied on different statements made after his accusations on this source. Okay, so I would argue this with the courts. Maybe, first off, I could just say, okay, I mixed up my tweets that I saw because I've seen a lot of tweets from her that are unhinged. And they're trying to say, well, the one that you said you saw was after the time that you said that she sucked dick for money. Even though she has a laundry list of tweets predating that I've seen plenty of times. They're trying to say that, no, you didn't see those. You just alleged she sucked dick. And then you found out she did afterwards. It's like, so I was right? How is that defamation then? The pretzel that they're trying to twist themselves into with this is impressive. I got to be honest. Like, you got to have a broken brain to represent this situation, which I would argue they do. In sum, the fact that months before the statements plaintiff made, defendant made a joke and said she worked in sex very broadly does not establish. You can't tell the judge she made a joke. Jokes are not on X. It is up to interpretation. You can't tell me it was a joke afterwards if I didn't read it as that. That literally does not fly in any court that I've ever seen. Just a joke, bro. Just a joke. Hey, come fight me physically. Just a joke, bro. It's totally just a joke. I don't have any issues. Just a joke.
And if you have a problem with that, come fight me physically, bitch.
You can't say it's just a joke. That how did you pass the bar if you're saying what she said was just a joke? The fact that you wrote this to the judge and say it utterly refutes false allegations is insane to me. And then they end it. As always, I thank the court for its time and attention to this matter. Respectfully, J. Remy Green. So that is their response to Ron asking for this to be dismissed. Netflix Forum says, I would never say, come fight me, and then say it was a joke. Well, it clearly was not a joke. And this is someone that, oh shit. Am I in trouble if that's serious? Yes. It was a joke. It's like, no. You don't, it's not revisionist history here. That's not how the courts work. We got an update. And this update came from Ron today. And he messaged me information that I'm not going to read because obviously that's like the attorney-client thing. But this was the summary of the information that he passed along to me. I said, update. We've been denied a pre-motion conference, which might sound bad, but that's actually good. The judge sees no need to talk us out of filing. Both sides now must agree on briefing schedule by May 27th. And the TLDR, we've been given the green light to file the motion to dismiss. Now, if you recall from the letter that was sent previously, they were trying to say that, hey, judge, they clearly don't understand what we're suing for. Here again, judge, look at all this information. This is what we're suing for. They don't understand it. So could we please get a brief telephone call to crystallize it and make it more efficient? The judge has responded to both saying, no, that you guys can file a motion to dismiss. Like the judge, I think this is very telling because I think if the judge, again, this is all in theory, who knows what's going to happen here. But if the judge is looking at this letter and being like sympathetic to Alyssa's side, the judge could have been like, oh, they're requesting a phone call. They want to actually talk to make sure you guys understand what the problem is here. I'm looking at the situation and I would argue that's probably what the judge is looking at too, with this jurisdiction being the hurdle. And I would almost argue that we don't even, I mean, far be it for me to say this, but that we don't even need the motion to dismiss the lawsuit. Because no matter what we write, there's not even needs for lawyers on this because the judge is just like, yeah, you guys couldn't prove jurisdiction, so it's getting thrown out. Like the only reason that Ron is needed here is one, to do all this because I don't know what the hell I'm doing, but two, to also push forward with the slap information and see if that's something that the judge would take into account. Again, who knows? Maybe the judge is just being very independent on everything and saying, no, I've heard enough from both sides. You don't need a phone call to tell them more. I don't need to hear more. I'm ready to see what their final motion to dismiss letter is. And maybe the judge reads it and is like, yeah, no, I see what Ron's saying, but no, I'm going to still allow this case to be heard, which could happen. That could still happen. So it's where we're at right this moment. But as far as the time frame for hearing back, that would be May 27th. Both sides must now agree on a briefing schedule by May 27th. So the letter from Ron doesn't necessarily have to be sent back by May 27th. We need to or not we, Ron needs to chat with Alyssa's lawyers to agree on a briefing schedule, which is a schedule of order of events. Like, okay, the judge has given the green light for us to file our motion. So we need to chat with Alyssa's lawyers to say, okay, what do you agree on? Typically, that's like a month or two for each step. It's a very slow moving process. So I would imagine it would be agreed on, like they give 1 month for Ron to write the letter, and then they're given 1 month to respond to it. But as far as I understand, and I could be wrong on this too, but the judge could at any point in time just shut it all down and throw it out at this point. Like all the information's there. So it's up to the judge to do what they will with the information as it comes in. So we'll see. We'll see.